Hello everyone. Today I'm going to start with the topic which is FIR. It is the first stage of a criminal proceeding. Whenever a case is started, it starts from the FIR, lodging of an FIR or filing of a complaint before a magistrate. So there are two situations. I have mentioned two situations here. First is lodging of an FIR and the second is filing of a complaint. So both these cases falls in two different offenses which is given under criminal law of India. So the first is cognizable case, and the second is non-cognizable case. Cognizable case are the cases in which the offense is of very serious nature, and the non-cognizable case are the cases in which the offenses are not so serious in nature that the police officer, if he doesn't have a warrant to arrest the accused person, the offense is of non-cognizable offense. Okay, so today I'm going to start with the topic FIR, which is provided under section 154 of CrPC. uh so in this uh, in this provision there are some clauses and there is a proviso in this provision which was inserted in the 2013 Amendment Act. So let's get start with it. I'm starting with the clauses first. The first clause is which says that uh, every offense which is committed and it is of a cognizable nature, the information shall be given to the police officer, and the police officer is duty bound to reduce it into the writing if the information is given orally. Second is, first is that such information shall be reduced in writing. The second is it shall be read over to the informant, like whatever that police officer is writing down in the FIR, the content of the FIR, whatever the content he is writing, he shall read it over to the informant to confirm it. Okay, and the third one is that it should be signed by the informant, the person who is giving the information to the police officer about such offense. That information shall be signed by that particular informant. And the last one is the substance of that information should be recorded in the book which is maintained in every police station. Like the book is basically like, if any offense is committed and the information regarding such offense is received by them by by telephone, or if any informant has come physically to the police station to give the information, the police officer shall enter make entry of such offense in that particular book. Okay, so next we come to the proviso. Let's come to the proviso. The proviso was inserted in the 2013 Amendment Act. It was made after the Delhi gang rape. It was a famous case, and after that this particular amendment has inserted a lot of provisions in CrPC and in IPC also. So in this section 154, this proviso was appended. So it was completely about the offenses which are committed against the women. So the first clause is, if any woman comes to the police station to give information regarding the offenses especially which are committed against the women, uh, such information shall be reduced in the writing by a woman police officer only. This is the first condition. Second is, if the person who against whom such offense is committed, if such person is permanently or temporarily disabled, whether physically or mentally, then the police officer shall record such statement at the residence place of that particular person. and the whole scenario, the whole recording of such statement shall be videographed. And the last point is that the police officer shall get the statement recorded in front of the judicial magistrate as soon as possible. It is given under section 164 clause 5A. After that, there are very general provision that the copy of the FIR must be given to the informant free of cost. No police station, no police officer can charge the informant for providing such copy to them. And after that, it is yeah, there is one relevant point over here, that if any police officer refuses to lodge any FIR in any cognizable case, in that particular case the informant can uh, send such information to the superintendent of police. What can he do is, he can simply write down whatever the content, whatever the complaint he has, he can write down it on a paper and can post it to the superintendent of police. Then the superintendent of police look into the particular matter, and if he thinks that yes, the case falls under the category of cognizable case, he shall direct his subordinate officers to investigate the that particular case. So this was all. There is a very landmark judgment on it also, which is Lalita Kumari versus Government of UP and others. In this case, registration of the FIR was made mandatory in the cognizable cases. And the second is preliminary inquiry is necessary in such situation. Like inquiry was made necessary in such situation. So this was all in 154 section. Thank you.